So can you get sued for competing with another business? You would think that the answer is a pretty straightforward, clear-cut no, but it might not be quite that simple. In fact, competing with another business in Washington State, generally, I'll tell you the short answer here is going to be most likely no, but there are some exceptions. Washington State generally promotes good, healthy business competition, as do most all other states. Everybody really wants businesses to compete with each other for the most part because it drives forward innovation, creativity, and overall better prices for the consumer. Generally, everybody accepts that competition is a good thing in the world of business. But there are a few doctrines that apply if you take your competition a little bit too far. And those can land you in some trouble. And that's what I want to focus on is the type of competition that can land you in trouble. And so there's a few doctrines that I want to talk about. The first being tortious interference with a contract. It's not a sexy sounding name that you hear all the time, like breach of a contract or assault and battery. Those are causes of action that people are generally familiar with. Tortious interference with a contract is not one that you've probably heard of before. But in order to prove it, the plaintiff needs to show 5 things. So if someone can prove these 5 things, they have a good beginning case to say that you are liable for some damages. If they can prove 1, the existence of a valid and enforceable contract. So 1, there has to be a contract. 2, that you knew about this contract. 3, that you took some sort of intentional action designed to breach or disrupt this contractual relationship. 4, that actually did disrupt or cause a breach of this contract, and 5, resulting damage. So what does that look like in practice? What does that actually mean? In order to establish this, let's say party A contracts with party B, and party C understands and knows that there is a contract between A and B. Let's say A and B are fish salesmen. A sells B to fish, sells fish to B. And C knows about this contract. And then C goes and interferes with this contract. Let's say they induced A or B to breach that contract, or they took some intentional action. Let's say they defamed A and said that A is a lousy, no good, rotten cheat, and B thereby, because B saw this, they breach their contract or they terminate their contract with A and they go with C. In that instance, there is a prima facie case or a beginning of a case for A to say that C is liable for tortious interference with the contract. Now, if you're thinking, okay, well, what if party A and B have a contract and party C, let's say that's you, is aware of the fact that they have a contract, and you want B's business. You are competing with A and you want to get B's business. And so for years, you are telling B you'll give him better prices. Let me know when your contract is up. I'd be happy to work with you. And then B on his own decides I'm going to terminate my contract with A and I'm going to go with C because he does have better prices. You didn't actually do anything to intentionally get him to breach his contract. That would be more in the line of fair business competition. You couldn't do anything to say, hey, please, if you sent him an email, for example, it says, hey, I know you're under contract, breach that contract right now. Please breach that contract. And here's the deal I'll give you if you go ahead and breach your contract. Then you possibly could be in line for tortious interference with a business or with a contract. Now, let's say your party C here and party A and B don't have a contract, and you want to get party B's business. Well, you would think, okay, well, no contract, no problem. I'm free to go ahead and compete. And that's where tortious interference with a business expectancy kicks in. This one is a bit harder to prove. It's a bit more gray. and a bit more amorphous. And it's a little threatening for some business owners if you're wanting to go out and compete in the world of business generally, because you want to make sure that you're not interfering with anybody else's business expectancy. You want to feel free to compete. And this doctrine is a bit more scary, because what it's saying in essence is, even if there isn't a contract, you potentially still could sue C if they're interfering with your business. But we'll get into that in a second. So what do they have to prove? You're a plaintiff and you want to prove that somebody else tortiously interfered with a business expectancy that you have. One, you got to show that you had the existence of a valid business expectancy. We'll get into what that means in a second. Two, that the defendant actually had knowledge of the expectancy. Three, that they did some sort of intentional act to interfere or induce causing the termination of the expectancy. So they interfered in some sort of way. Four, that the defendant interfered for an improper purpose or used improper means. And we'll talk about that one more later. And then five, that the plaintiff actually suffered damages as a result. So when litigating these types of cases, generally there are two elements that are hotly contested. Number one is the first one that's hotly contested, is there a valid business expectancy in what you're claiming? Two is generally pretty straightforward. Did or did you not have knowledge of the expectancy? Three is also pretty straightforward, whether they did an act or not, where there was something to interfere. Four, we generally talk about a lot more. Four is, did the interference, was it for an improper purpose or improper means? Well, how do we define what is an improper purpose? What does the law consider to be an improper purpose or improper means? And then five, proving damages is usually cut and dry. Is there damages, yes or no? So first, let's talk about what constitutes a business expectancy. So a business expectancy is more than just, it has to be much more than just, I own a business and I'm expecting that I'm going to get customers. Let's say I run a cell phone business. I sell cell phones or cell phone services. I can't go sue T-Mobile and say T-Mobile is interfering with my business expectancies by getting customers in general, because I sell cell phone services and so do they, and I have a business expectancy that I'm going to get customers and they're taking them from me. That's not enough to show a business expectancy. According to this case, a plaintiff must show that the future opportunities and profits are a reasonable expectation, not based on merely wishful thinking. This case further talks about what they mean more by a reasonable expectation, and really what it boils down to is kind of what I put here in this example. This is a good example of what a real business expectancy is. It's not quite yet a contract, but you have a good faith, reasonable belief that you're going to be receiving business. So party A, let's say they have a long-standing relationship with party B. Party B announces that they're going to be using party A as its material supplier for the foreseeable future. Let's say maybe party B is a big construction company and party A is like a concrete supplier. And so maybe party B announces this and they put it on Twitter, or they make it known to the public, or they maybe even just make it known to party A, but they say, hey, we really like you. You've done good work for us in the past. For the foreseeable future, we're going to be using you exclusively as our material supplier. Now, they don't have a contract or a written contract stating that, hey, I have to use you as our material supplier for the foreseeable future. But party A has a reasonable belief and a good case to say, I have a business expectancy that I will be receiving anytime that there's work as a concrete supplier, that party B is going to be giving that over here to me. So they have a valid business expectancy if there's something to that nature. Now, what constitutes improper purpose or improper means? So if someone went to go interfere with that business expectancy, what would be improper and what wouldn't be improper? The law says that it's improper if the plaintiffs can prove that it was wrongful by some measure beyond the interference itself. Okay, so it's saying that just the fact that there was an interference isn't sufficient to show that it was improper. So if there's a statute, regulation, recognized rule of common law, or an established standard of trade or profession, So if there's a very clearly established standard amongst concrete suppliers in the construction industry that you will not solicit business of a bigger company or bigger construction company that offers jobs continually to somebody else, then possibly competing in that instance could constitute an improper purpose or improper means. So here's another example. Let's say this one's a little bit more clear. Party C, we keep the same facts. We've got party A and party B, and party A is the concrete guy, party B is the big material or the big construction guy, and he's given all of his business to party A. So party C comes in and starts posting lies online and sending them directly to party B, and they start telling him that, hey, that business is they're cheaters and liars and thieves, and they steal people's money, and they do all of these horrible things, none of which is true. And they start saying all this clearly defamatory stuff about party A solely for the purpose of getting their contract. They just start writing messages to party B saying, hey, A is a liar, he's a dirty, rotten scoundrel, he's a cheat, and he's a stealer. He's gonna screw you over in business. Give me your contract instead, give me all your work. And as a result, party B says, oh yeah, well, I don't want to work with that guy if he's as terrible as you say. Sure, I'll give you, party C, all of my concrete work from now on. That would be an improper purpose or an improper means, because there are statutes saying that you're not allowed to defame people or say things that aren't true for the purpose of harming them. So in that instance, we have a very clear improper purpose or improper means, however the court wants to define that one. So those are two basic, or a brief rundown of the law on tortious interference with a contract and tortious interference with a business expectancy. Of course, there's a lot more that goes into an analysis. So if you're looking at a particular set of facts, if you're worried about wanting to compete with somebody, you should also probably consider whether you're under a non-compete. If you've signed a non-compete, really you should just give a lawyer a call. There's a lot that goes into non-competes, and Washington State has done a lot to make these significantly less effective. For example, if your non-compete was signed, let's say a year after you started your employment, it needed to be supported by additional consideration, meaning it needs to be supported by a payment outside of just you working there, outside of your normal salary, in order for it to be valid. Additionally, there's a salary threshold that goes up every year. As of this year, if you're making $120,000, right, this figure here, $120,559.99 or more, you are subject to non-competes. If you're lower than that, then a non-compete is not enforceable against you. So if you signed a non-compete, but you want to go out and compete or start your own business or do something else, it's best to talk to an attorney to see if that non-compete is even enforceable, because it may not be. If you have any additional questions, you want to know more about competition in business and whether it's legal or not, I'm happy to talk and answer any questions. Thanks.